As a number of people isn't aware of the importance of will writing, Henry Muhangi, an advocate of the High Court and also the head of legal department AMDA, explains why everyone must write a will.
Henry Muhangi is my name. I'm an advocate of the High Court. I am also the head of legal for AMDA. So one of the reasons why we come to the villages of Ankole is to facilitate finding solutions to some of the challenges that the locals face. And for this particular visit, we have emphasized will writing. We are aware that many people do not write wills, and increasingly families are getting engaged in conflict when their heads pass on because they did not leave behind any sort of arrangement as to how their estates should be divided. More importantly, land in Ankole is becoming a scarce commodity. So rather than have siblings fighting over property, rather than have mothers being thrown out of homes, we are preparing the communities about the advantages of will writing. And today we also took them through a step-by-step process as to how to write a good will that will not be challenged.
For a will to be considered valid, certain factors must be considered by the owner.
Very importantly, you must write a will aware that it is supposed to have certain contents. There are certain provisions within the law that would invalidate a will. And maybe those are the circumstances where even when the deceased thinks he left behind a will, for some reason, the will is vitiated by those who remain behind or by court itself because it did not follow certain processes. So today's activity was to show them those circumstances when the supposed will may actually be challenged with ease. But where a will has been written, it has been signed by the person who wrote it, it has been witnessed, it fits within the prescriptions of the law, then the law will respect that will.
I'll ask you another question. Does someone need a lawyer to write a will?
Definitely not. It is a very simple exercise, like we've demonstrated through today's session. It doesn't have to be in English. It is in the language that the person writing it understands, provided they are able to describe themselves in the will, describe their property, describe the people they are giving it to, have it endorsed by themselves in the presence of two witnesses. You have not left out people that you should be providing for. You do not have to have an expert to write it for you.
For a few individuals who write their wills in the form of revenge or out of anger, Muhangi says that the will be challenged if the victims report to the courts of law.
Most importantly, you must write a will when you are in a proper state of mind. It is actually important that you state so, that you've not been coerced and you are in a proper state of mind. Now, if you use the will to mete out punishment against children who are legitimately yours, you leave them out of a will and you leave your property with someone who is not expected properly to receive anything from you, the presumption is that you did not write it when you are in your proper state of mind. That will most likely be successfully challenged.
Okay.
So do not use it to punish. Write it when you are in your proper state of mind and be as honest as you can with yourself. Do not leave out anyone that is your son, child, beneficiary. If you do, state properly in your will why you have left them out. Even where the will is written, before it is implemented, it goes to court. Court will give you permission to implement the will. So whoever has a challenge against the will, the proper place to go is court. If you've been left out of a will and there are legitimate reasons as to why you think you should be part of it, then you move to court and seek to challenge that will. And court will listen if there are very legitimate reasons as to why you think you are left out.
For instance, I don't have money to hire a lawyer. Am I going to be helped by the government?
For starters, as AMDA, we have a partnership with Uganda Law Society, specifically the Legal Aid Project of Mbarara. Now, tomorrow, when we meet cases of that nature that require to go to court for free, those individuals, our friends from the Legal Aid Clinic, will be present to take them on. There are pro bono services provided by Uganda Law Society that individuals who legitimately cannot get money to hire a lawyer will be assisted free of charge.
The biggest challenge in rural areas people face is the lack of information, as many of them die and leave no will behind. And in most cases, this affects the women and children more.
Lack of information is a very, very dangerous thing, especially where people die without leaving behind a will. Individuals think you can wake up one morning and distribute the property of the deceased party. That is illegal, and we've taken every effort to explain it. And secondly, women have challenges, especially getting recognized as owners of property. Even where they participate in building wealth for families, the decision making usually leaves them out. Most of the serious questions we got were from women who are asking, can my husband give away everything we have worked together for in a will without involving me? And that is a big, big challenge that women are facing.
Story was compiled by M. Frank and Kisto Henry for UCTV.